Welcome to our second lecture covering Chapter 2. The name of this chapter is Contract Basics and Overview. In our first lecture, we covered the definition of contract and the elements of contract. And here we have the elements stated again. Let's just do a bit of a refresher of what we covered in Lecture 1 about Chapter 2, and then we'll move on to new material. We're going to talk about the 4 elements of contracts. The first element is agreement. If we don't have an agreement, we don't have a contract. We might have something, it might even be enforceable, but it's not a contract. So this is our first element, our first requirement, our first necessary ingredient. Then we have consideration. This is another necessary ingredient. We need consideration from both parties to the contract. Both parties also have to have legal capacity or competence to enter into the contract. And finally, both parties have, the contract itself has to be legal, it has to have a legal object. If we're missing any one of these 4 elements, we don't have a contract. Now, one of our elements here, agreement, has some elements of its own. In order to have an agreement, we need 3 things. If we're missing any of these 3 things, we don't have an agreement. And if we don't have an agreement, we don't have a contract, right? So we need to have an offer. That needs to be followed by an acceptance. And the parties have to have mutual assent, a meeting of the minds. We need to have all 3 of these things in order to have an agreement. If we have an agreement, consideration, capacity, and legality, it's very likely we have a contract. But sometimes there's a 5th requirement, and that is a writing. We don't call it an element of the contract because most of the time it's not required. It's a good idea, but it's not required. And the key document for this is statute of frauds. That explains whether we need a writing or not. Kind of a weird name, misleading name for the test to see whether we need to have a writing or not, but that's the name of the document. And we'll talk more about this in a later chapter. In fact, we'll talk more about all of these topics in later chapters. Just write this up here. So that's kind of our summary of our first lecture for Chapter 2. Let's start on some new material now. Okay, imagine that I am hosting Thanksgiving dinner. And this year I'm a newlywed, and so it's just going to be my husband and me. We've decided to just have a little intimate Thanksgiving dinner, he and I. And you know what? His favorite pie is pecan pie. It's I think that's the favorite thing that he has for the whole Thanksgiving meal. So I get out a 9-inch pie tin and I make a pecan pie. And you know what I do? I just cut it in half. And this is my husband's side, and this is the wife's side. Actually, the wife's side's bigger. I shouldn't have done that. Makes me seem like not a very nice wife. But anyway, however I do it to make it even, that's what we do. And so my husband has half and I have half. The next year, we decide to have Thanksgiving with a couple that we know, maybe our next door neighbors. They are a husband and wife. And so the next year, we have to divide it up into 4 pieces. It's the same pie tin, it's the same amount of pie, but we've decided to cut it into more pieces. So now we have 1, 2, 3, 4 pieces. Pretty big pieces, but the next year, we decide to have our pie with his parents and my parents. So we have 6 people there. See if I can pull this off. Not so great, but you get the idea. Same pie tin, same amount of pie that is going to be consumed, but now we have 6 pieces. And you can see how what I'm getting at is there's lots of different ways of breaking something down. You can have, you can divide it up into relatively big pieces or relatively small pieces. And so we're going to talk about different ways of dividing up that pecan pie or dividing up the world of contracts. One way of doing that is to just divide up contracts into 2 categories, one being bilateral and one being unilateral. The way I keep these straight is a bilateral contract starts with the word bi or 2. as in bicycle. Bicycle has 2 wheels, bilateral has 2 sides. Lateral means sides. Unilateral, uni, meaning one, unicycle. Unilateral, one-sided, unicycle, one wheel. So when we're talking about bilateral or unilateral, you look at that initial prefix, what goes before the word, to figure out what's going on. But there's other ways of dividing up the world of contracts. One is to look at express or implied contracts. Another is to look at whether the contract is executed or executory. A fourth way is to consider whether it's void, voidable, or unenforceable. And then a fifth way is to consider whether it's formal or informal. So let's go forward and examine these different ways of dividing up the world of contracts. So what is a bilateral contract? We already know that there's 2 things going on, and the 2 things are promises. It's a promise, this is our first thing, exchange for another promise, our second thing. An important thing to keep in mind when you're considering whether a contract is bilateral or unilateral is it doesn't really have much to do with the substance of the contract. It has to do with the form of the contract. Virtually any contract can be phrased as bilateral or unilateral. It's all how you structure it. So let's look at an example of this. We have 2 parties, A and B. We'll say this is Adam and Bob. So Adam says to Bob, will you promise to paint my house for $5,000? And B says, yes, I will paint your house for $5,000. He's not doing anything, but he's promising to do something. So A is promising, it's implied, so it's not exactly stated, but it's implied that A is saying, I promise to pay you $5,000 if you promise to paint my house. And B says, I promise to paint your house if you promise to pay me $5,000. So we have 2 promises. It's a bilateral contract. But here's another way that we could phrase that same transaction. Adam this time could say to Bob, I will pay you $5,000 if you paint my house. Not if you promise to paint my house. I don't want your words. I want your deeds. I want your actions. So you can say all day long, yeah, I promise to paint your house, but you know what? We don't have a deal until you put that first stripe of paint on my house. How does B accept that? Bob accept that? He doesn't accept it with words. He accepts it with paint. And so this is a promise that is exchanged for performance or an action. Again, when we use the word performance here, we're not talking about like the symphony performing or something like that. We're talking about a house. The way a house painter performs is by painting the house. It's an action. So bilateral is a promise for a promise. A unilateral is a promise for an action. And in this case, the offeror, Adam or A, makes the promise. The offeree, Bob, is the one, if he accepts by action. So A, the offeror, is always making the promise. The issue is what the offeree, if he chooses to accept, how does he demonstrate his acceptance? Does he demonstrate it by making a promise, or does he demonstrate it by taking an action? That's the distinction. So you can see usually virtually any deal can be made into either a bilateral contract or a unilateral contract, depending upon how that offer is phrased. So now we're going to go to our next category. We've covered bilateral versus unilateral. Now we're going to look at express versus implied. So what is an express contract? Your first thought might be, or at least my first thought would be, well, we're talking about written contracts now, right? It's express, it's written, it's inked paper. Well, certainly written contracts would be express contracts, but you know what? It's not restricted to written contracts. Oral contracts, where the actual terms are stated out loud or pointed to, or it doesn't have to be words, but some way that it is unambiguous what is meant, that is an express contract. The parties know exactly the terms and the conditions. It is expressed. Now, as I said, an oral contract can be an express contract. But, oral contracts aren't the best ideas, especially when you're talking about something that is important to the parties. Now, if you're talking about selling a pencil for 10 cents, it seems a little silly to reduce that to writing, because what are your damages if the deal goes awry? 10 cents. Who really cares one way or the other? But when it involves something that matters, it's a good idea to put it in writing, even though legally it's not a requirement. So that's what an express contract is. It can be oral or in writing. It's one that is explicit about what the deal is. Another category of contracts is implied in fact contracts, which we're going to talk about in the next slide. But let's first of all look at this picture before we go into more details. You can see here I have a big circle with a line through it, and then I have another smaller circle over here. The reason that I have it divided up this way is that both express contracts and implied in fact contracts are in fact contracts. So this is the universe of contracts. But we have something called an implied in law contract, which actually isn't a contract at all. So I'm just going to put not equals contract. So we might call it an implied in law contract, but it's really an oxymoron. It's like referring to the walking dead. Well, if you're dead, you're not walking, and if you're walking, you're not dead, unless you're a zombie, right? So terms that mutually exclude the other, and that would be an example of implied in law. If it's implied in law, it's not a contract. If it's a contract, it's not implied in law. So let's look at what we mean when we talk about implied in fact. And my guess is that you have entered into an implied in fact contract already today, unless you're watching this first thing in the morning. Because guess what? You've probably bought something. Maybe it was lunch, maybe it was gas, maybe it was you paid some bills. Lots of different ways you probably engaged in implied in fact contracts. So what is an implied in fact contract? This is where a contract is entered into where we look at the circumstances, the conduct of the parties. We can't look to their written or spoken words. So you know what? I'm running low on gas. I stop by the 7-Eleven. I pull my car up. My gas tank lid is on the passenger side, so I pull my car up so that the gas tank is located close to where the hose would be. I get out my credit card, I swipe it through the reader, I punch in my debit number, I hit a button to indicate which grade of gas I want. I unscrew the cap on my gas tank, I put the nozzle in the gas tank, and I squeeze the thing that starts it going. I don't know what you call that, but anyway, it starts going and it starts coming out. And I leave it in there until I get the amount that I want. Maybe I want a full tank, maybe I want a certain amount of $10 worth of gas or whatever, but let's say I fill it up until it's full. Well, eventually it cuts off, and so then I take the nozzle out and I return the nozzle to the place that the slot for it, and then there will be a little message on screen saying, do I want a receipt or not? And I'll probably say no, and I go about my business, go back in my car. Throughout this entire process, I haven't written a thing, I haven't said a thing, I haven't spoken to a single person. I haven't even really paid attention, other than knowing to enter in my debit password. I haven't really paid attention too much to the various screens that I need to click on, because I've done this a million times. I don't really need to pay attention to it. That's an implied in fact contract. It's the circumstances. The gas, 7-Eleven knew why I was there. They knew I wanted to buy gas. I knew why 7-Eleven was there. They wanted to sell me gas. This was an easy transaction for us to figure out. We didn't need to have extended conversations. Let's consider the situation of when you're buying groceries. So we have Anne here. Anne has her cart full of groceries. She pulls up her cart to the conveyor belt in the front, and she puts her items on the conveyor belt. The employee scans each items and puts them in a bag, and maybe there's a colleague who puts them in the bag and puts them in the cart. And then the employee announces a dollar amount, $47.32, please. And Anne perhaps enters her credit card information, perhaps she gives the employee cash, and the transaction is complete. She never said to the clerk, I would like to enter into a contract with Kroger to purchase these items for these particular prices. Is that agreeable to your employer? No. If Anne were to have said that to the Kroger employee, that Kroger employee would have been kind of freaked out. What is she talking about? Why is she talking about contracts and things like that? Is this candid camera? Am I being punked? What's going on here? Right? Because people don't have that conversation because it's obvious. Anne knows exactly what she's there for. The Kroger employee knows exactly why Anne's there. We don't need to have a conversation about that we're entering into an express contract. No, but we are still entering into a contract. It's implied in fact. And we know it's a contract because if after the groceries are bagged and put into Anne's cart and the Kroger employee announces that's $48.57, Anne says, oh, that's nice to know. Well, I'll have, you have a good day. I'm going to head on out. The employees will be like, lady, you need to pay me. Oh, no, I don't think I will today. Thank you, though. Well, no, you can't leave with those groceries unless you pay me. Oh, no, I'm going to leave with, no, you can't leave with them, right? I mean, the employee would get insistent at this point. Similarly, when the Kroger employee says to Anne, well, that'll be $48.97, and Anne gives the Kroger employee the money, and she starts wheeling the groceries out, if the Kroger employee goes, you can't take those groceries, they belong to Kroger. And it's like, well, I just bought them from you. You gave me money. I mean, that was a gift. Thank you very much. But no, those groceries belong to Kroger. You can't take them. We'd all say that Kroger employee is crazy, right? Because we understand that Anne and Kroger were entering into a contract even though it was an implied in fact contract. So you can see these are super, super common events, and they are completely and absolutely legitimate contracts. But what isn't a legitimate contract is an implied in law contract. I mean, after all, it looks like it's almost the same phrase, right? The only difference is fact versus law. So you think to yourself, well, gosh, if implied in fact contract is a contract, surely an implied in law contract is a contract. But it's not. It's what we call, and you can see these terms are in red, so they're important vocabulary terms to be familiar with. An implied in law contract is a quasi-contract. Let's pause here and talk about quasi. The way I like to define quasi, this is just me, but is quasi means kind of, sort of, but not quite, pretty close, but not really. It's, close but no cigar type idea. So a quasi-contract is something that isn't really a contract, but it's pretty close to a contract. I mean, it's quacking almost like a duck that you might think to yourself, is it a duck? But you know what? It's not a duck. So that's what a quasi-contract is. Quasi-contract isn't really a contract. So a quasi-contract is a contract that's implied by the law, imposed upon the parties by the law. It's not a contract, but the law comes in, and when we say the law, we mean a judge comes in and says, you know what, this isn't a contract, but we're going to treat it as if it were a contract. We're going to pretend it is a contract. Now, judges don't like to do that. Judges like rules. They like order. They like to follow the procedure. They want to call a sugar cookie only when it's got sugar in it. They want all those elements to be there. If you're missing the sugar, they're very much inclined to say, there's no cookie here. I mean, there may be a cookie there. There's no sugar cookie here. So it's not an easy jump to persuade a judge to enforce something that isn't a contract as if it were a contract. Usually, when this happens, the court does it because it feels that there would be unjust enrichment, that somebody is pulling a fast one on somebody else. Okay, so here's our definition of quasi-contract. Quasi-contract, it's an obligation imposed by law to achieve equity, usually to prevent unjust enrichment. So it's imposed by law, but it's not something that is a contract itself. We call it an obligation, but we don't call it a contract. So what's unjust enrichment? Here's another vocabulary term, lots on this particular slide. Unjust enrichment is probably exactly what you think it is. We all know what unjust means. Something that's unfair, that doesn't feel right, that makes you think, gosh, that shouldn't be that way. That idea is what we're getting at with unjust. Enrichment, we all know what it means to be rich. So enrichment means somebody has gotten stuff that he really wasn't entitled to. That's the idea of unjust enrichment. An example could be, let's say I bought 10 lotto tickets with my lucky numbers, and I dropped one on the floor, and I don't realize I dropped one on the floor. I leave with my 9, and the one that dropped on the floor, somebody picks it up, and that's the one that wins. That's the one that had the particular combination of lucky numbers. That person could have turned to me and said, hey lady, you dropped one of your lotto tickets, here you go, but he chose not to. And so he is being unjustly enriched. He's winning that lottery when I didn't. That's an example of unjust enrichment. It doesn't do with contract law, but that's just kind of an example of what that term means. So you can see when you have that dynamic in one of these situations, we have something that isn't quite a contract, but we have somebody really taking advantage of somebody else. The court might say, we're going to treat it like a contract because it just doesn't feel right not to. Let's consider the Latin term quantum meruit. It means the amount that somebody is owed, what somebody has earned, in other words. This is a term, it means what would be reasonable compensation that this person should get based upon the benefit that somebody else got. Let me give you a quick little example of how that might play out. Imagine that in my neighborhood there has been some hailstorm, and lots of the roofs in my neighborhood are in bad shape. And so roofing companies have gone around and inspected people's roofs, and in some cases they have said, yeah, you need a new roof, and they've dealt with the insurance and gotten all those things worked out. There was a company that came by my house and evaluated my roof and found that, yes, I had some significant damage. But you know what? I didn't really want to get it fixed. It seemed like a hassle. I had a high deductible on my homeowner's insurance, and I just said, no, I'm not going to do it. But my next door neighbor, who had a similar amount of damage, that neighbor said, yeah, I'm going to do that. And so he entered into a contract. We'll call my next door neighbor Bob. Anyway, Bob enters into a contract with Roofers R Us. And it just so happens that Bob's and my houses look virtually the same. I mean, it's the same floor plan. It's the same facade. It's the same paint. And the only difference really is the street number. Anyway, so Roofers R Us enters into a contract with Bob to replace the roof. I happen to work from home. And so the next day I hear some sounds outside my house. I look outside and I see the Roofers R Us truck is there. And I think, oh, that's kind of neat. Good for Bob that he's getting the new roof. But instead of the roofer workers going over to my neighbor's house, they head to my house, and they've got big ladders, and they're putting the ladders up against the side of my house. And I'm thinking to myself, this is weird. What are they doing? And then it occurs to me, wait a second. They think that this is Bob's house. They are going to work on my roof. I'm thinking to myself, this could work out pretty cool for me. So the workers work all day, and about lunchtime, one of them knocks on the door and says, hey, do you mind if I get some water, if I turn on your tap and get some water? I go, sure, go for it. Yeah, of course, do whatever you need to. Another worker later on the day says, hey, do you mind if I use your bathroom? I go, sure, no problem, go for it. Another one comes in and asks if he could use my landline. Let's say I have a landline and he needed to make a call. I go, sure, go for it. So it's obvious that I know that they're working. After all, it's pretty noisy, the work that they're doing. I've seen the trucks. I've seen them. I know that they're working. Anyway, they continue working for several more days. And then finally they're done. And so one of the workmen, I guess maybe the foreman, comes up, he goes, "Hey, you must be Bob's wife. Well, I need you to sign off on the work that we've done." And I say, "Well, you seem like you've done a great job." In fact, the foreman shows me, we climb up the ladder, we walk around, we look at it, it looks great. I'm very pleased with the work that's been done. He goes, "So all I need from you is a check." And I go, "Oh, well, that's great that you would like a check from me, but I don't really think I'm going to give you any money." He goes, "Oh, well, but we have this contract, and the contract specifies that you're supposed to pay me $3,000 when the work is completed to your satisfaction. Has it been completed to your satisfaction?" I say, "Oh, yes, this is a great job. But I'm still not going to pay you the 5,000 bucks or the 3,000 bucks." And he goes, "Well, why not?" I go, "Because I'm not Bob and I'm not Bob's wife. And in fact, this isn't Bob's house. I don't have a contract with you, but thank you for the free roof," right? Well, I have been unjustly enriched under those circumstances, right? I received something, a new roof that really doesn't belong to me, and that has caused the other guy, the Roofers R Us company, to be out some serious money, supplies and labor costs. And so the courts are likely to say to me, "You know what, Groover, you could have stopped them. I mean, when you saw the truck arrive and the ladder went up against the side of your house, you knew then what was going on. You definitely knew what was going on when the person asked if he could run water to get something to drink, and when the person wanted to uh, use the bathroom, and when somebody else wanted to use your landline. You knew long before the end of the transaction. You could have stopped it. You could have come out there and said, 'Hey, I think you mean to be next door, not here. We don't have a contract with you.' But you just didn't say anything. And so therefore, we're going to treat this situation as if you did have a contract with Roofers R Us. That's that quantum merit idea. I'm still going to have to pay the reasonable value of that roof even though I didn't have a contract. Let me give another example of that. Okay, so Bob is tooling around town in his car. He's unfortunately, in a bad car accident. He's knocked unconscious and he's just really, really badly hurt. 911 is called, the ambulance arrives, they rush him to the hospital. He arrives at the hospital in the emergency room. The doctors look him over and say, "Bob needs emergency surgery." Unfortunately, Bob is unconscious and he was traveling alone, and nobody knows who Bob's spouse or parents or responsible person might be. So the doctor has to decide, well, do we wait to perform the surgery until Bob regains consciousness or we can find his next of kin? Well, if we do wait, he'll be dead. Or we could go ahead and perform the surgery even though Bob is unconscious. We might save his life. That sounds like a good thing. So they proceed with the surgery. The surgery fortunately goes very well. A few hours later, Bob is waking up from recovery. The surgeon comes in and says, "Hey, Bob, we performed emergency surgery. We were able to save your life. You're going to fully recover." Bob says, "Thank you, thank you, thank you." And so the surgeon then goes, "And certainly there will be a bill that we'll be sending to you, but don't worry about that now, but there will eventually be a bill." And Bob's like, "Well, I thank you for saving my life, but I'm not paying any bill." Surgeon's like, "Well, what do you mean you're not paying a bill?" "Well, you and I didn't have a contract. I never agreed to pay you for saving my life." Um, Under those circumstances, the surgeon can sue Bob, and the court would say, "Bob, you got the benefit of the surgery. You have to pay for it. Otherwise, emergency room doctors aren't going to be willing to perform surgery on the next unconscious patient. And that poor unconscious patient is going to die because he was not able to consent to the surgery. And we want people to survive those types of accidents when they can. And so it's socially useful for us to require people to pay for that life-saving surgery." That's another example of quantum merit or implied in law contracts. So now we've talked about bilateral versus unilateral. We've talked about express contracts as well as implied in law and implied in fact contracts. So we actually have two categories here. And now we're going to go on and talk about executed and executory contracts. So what is an executed contract? This is when the contract has been fully performed. There's nothing left to do. Now, many times people in everyday conversation will put a different meaning on executed. They will take it to mean that it's just been signed. So an executed contract is a signed contract, but maybe the parties haven't actually completed the terms. We actually do say to execute a contract means to sign it, but an executed contract is not merely a signed contract, but a contract where both parties have done what they say they're going to do. So let's go back to our unilateral, our bilateral situation. So let's say that Adam and Bob sign a contract that says, Adam says, I will pay Bob $5,000 when he paints my house. And Bob says, I promise to paint Adam's house because he will pay me $5,000. And they both sign it. So now we have a contract that has been executed by both Adam and Bob, but it is not an executed contract because Bob has not painted Adam's house yet, and Adam has not paid Bob for painting the house yet. So let's fast forward a few weeks go by, and Bob has actually finished painting the house. Now Bob's responsibilities under the contract are executed. He doesn't have to do anything more, but Adam still has to pay. So it is not fully executed until Adam has paid as well. So what do we call a contract that's not executed? We call it executory. This arises when there are still duties that needs to be performed. The house still needs to be painted, and or the money still has to be paid. Future obligations exist. And of course, an executory contract will have been signed. Again, we can have an oral executory contract, so it wouldn't be signed, but if it's a written contract, typically the parties will have signed it. This is, so let's go talk about void, voidable, and unenforceable. Okay, let's first of all distinguish between void and voidable. You can see they start out the same, both start with the word void, but with our second category, we have a suffix on it, able. If we were to say that something is paintable, it means it can be painted, right? Or edible, it can be eaten, right? Or drivable, it can be driven. Well, same way with voidable. A voidable contract is a contract that can be voided. It doesn't mean it will be voided. When we say something is edible, it doesn't necessarily mean it will be eaten by anyone. It just could be eaten by somebody. When we say that car is drivable, it doesn't mean that it will be driven. It just means that could happen. That's an option. And so that's kind of from a terminology perspective, that's the distinction between these two. So let's first of all look at void. A void contract is a contract that has no legal effect. It's that oxymoron situation, the living dead, the walking dead. If it has no legal effect, it's not really a contract, because by definition a contract is something that has a legal effect. So by saying it's a contract that doesn't have a legal effect, we're really saying it's a contract that's not a contract. I like to draw an analogy between contract law and family law in this situation. So let me give an example. Imagine that I was adopted as an infant, and I grow up and I start dating Bob. We date for a while, we decide to get married, we get married. We're both adopted people, and we are happily married for a while, and then for whatever reason I decide that I'm going to research my family tree. And so I do, and I try to find my birth mother. And Bob kind of thinks the same thing. Hey, you know, if my wife is going to do this, I'm going to go do it too. It might be interesting to find out who my birth parents are. So we both do it. We both hire some company to do that. And the company comes back and tells us, you know what? awkward. Yeah, I'll have to say mom and dad. It's like, ooh, gross, awful. Well, guess what? Even though we didn't even know we were brother and sister, the fact that we were brother and sister makes our marriage void. There's nothing we can do to fix it. There's no document we can file with the court that's somehow going to make us be married after all. It's an unsolvable problem. And in fact, it's not just that we can't be married going forward. The law would say we never ever were married, because a marriage between siblings is like The Walking Dead. It's just not, no, you just can't do that. If you're siblings, you just can't legally be married. I mean, you can lie, you can make it seem like you're married, but it's a fraud. It's just not going to happen. So let's consider the voidable contract situation and see how that's different. So this is a contract that could transition to this category, but it could also transition into the valid category, which I don't actually have on this slide. I guess I have that on the next slide. Actually, I don't have one for valid. A valid is just a good old-fashioned enforceable contract. So a voidable contract can go either way. It can go into this land of bad stuff, or it could end up being just a perfectly normal, enforceable, lovely contract. It's all going to depend upon what the parties want to do. They have the option to get out of it if they want to. But if they don't want out, they don't have to get out. It's treated as valid until one of those parties says, nope, I'm choosing the void contract category. And what we call that decision to move a voidable contract to void contract, we call that a disaffirmance. We're disaffirming something, and that's the act of rejecting the contract. There's lots of reasons that a contract can be voidable. Just here's some examples. Intoxication, when the parties was really, really drunk or high. Insanity, when the parties was insane. When the parties was a minor. There's some type of fraud. Those are just some examples of the types of problems that could make a contract not enforceable. Let me give an example. I didn't really give an example. What would be an example of a contract that just, no matter what you do, it just isn't going to work? An example of that would be a contract for an unlawful purpose. So let's say I'm a drug dealer and I'm trying to sell Bob cocaine. Well, guess what? There is no way we can fix that. No court is ever going to enforce that contract because it's unlawful. We can't fix it. Now, a contract between a 17-year-old and a 19-year-old, that falls into the voidable category. It can become a valid contract, or if the 17-year-old changes his mind, doesn't want to participate in it, it can fall into the void category. It can go either way. The analogy I like to draw between voidable contracts and family law is an annullable marriage. An annullable marriage is a real marriage. It's just a marriage that the parties can still get out of, and they don't have to get out of it via divorce. They can choose to get out of it via an annulment. And an annulment says this marriage never really happened. So the parties get to kind of choose after the fact. If they want to stay in it, they're just going to be married just like anybody else. But if one of them says, this wasn't working out for me, then they can get out and they don't even need the divorce. They can just use an annulment. An example of this type of situation in Texas would be in a marriage between first cousins. So again, the same scenario. I'm adopted. I meet Bob. I marry Bob. Bob's adopted too. We research our family tree. And this time the company that's doing the research in the family tree discovers that we're first cousins. Well, under that situation, we could choose, one or both of us could choose to seek an annulment. But we might say, you know what, I mean, we love each other and we're okay with being first cousins and still being married. It's a little creepy, but it's okay. Well, under that circumstance, we could have a valid marriage. We doesn't have to go the route of a void marriage. Now, if Bob says, I want out, this is gross, I don't want to be married to my first cousin, then he could get an annulment. But if we both choose to stay in the marriage, it becomes valid. Then we have the category of unenforceable contracts. This is a subcategory of void contracts. This is when you have something that seems to be really a valid contract. It has all of the elements but something happens that turns it from valid to void. It could be that a new law goes into effect that changes what's legal. It could be that it's a particular type of contract that has to be in writing and you just didn't put it into writing. It could be that there was some intervening event that happens that makes the contract no longer in force, maybe a condition subsequent, which we'll talk about later on. But the main thing to keep in mind is that an unenforceable contract is essentially a void contract, equals void contract. So we have void, voidable, and valid. Those are our big categories. And now we're going to talk about the last way we can divide up our world of contracts. And by the way, as you've probably figured out, the lines that we do between unilateral and bilateral, they might be like this, but the lines that we do between express and implied, it might be like this, and between executory and executive. So I mean, all so you might have a bilateral contract that's express and executory and voidable. And then you might have a unilateral contract that's implied, executed, and voidable. You know, you can mix and match from these categories. They don't all track. It's not like if it's bilateral, it's always expressed, it's always executed, it's always void. In each one of these categories, you can have different combinations, so to speak. So let's look at our last way that we're going to talk about today, at least, about how we can divide up the world of contracts. So we have two categories. We have formal and informal. These terms are a little bit misleading in my opinion. When I hear the term formal contract, I think to myself, oh, it's going to be, you know, a 100-page contract with lots of attorneys and paralegals involved, you know, hundreds of paragraphs, really, really complex and expensive deal. That's what I think of when I think of formal contract. But you know what? That's probably not a formal contract. When we use the word formal, we can mean several different things in English. I mean, one meaning is that it's kind of a big deal event, something that's significant. We might say it's formal. For example, graduating from college, that's a formal event. You don't show up in your flip-flops. Or we might use the term formal to suggest that it's that there is a certain level of seriousness associated with it, and a certain dress that you wear, or a certain way that you behave. For example, if I'm meeting the Queen of England, I'm going to have to be dressed in a certain way, and I'm going to have to know, do I curtsy, do I bow? What are the rules about how I interact with the royalty? Those might be examples of formal things. But there's another meaning we have with formal, and that is that it's about the form of something. So then this is the meaning that we're actually focusing on here. A formal contract is a contract that is in a particular form. So this second definition is the one that we are going to use for this course. Just don't even pay attention to this first definition. So a formal contract is a contract that is in a certain format or form. And one of those formats is when a seal is required. Now, the vast majority of contracts don't need seals. I act like maybe 5% of contracts need seals or need a particular format. It's actually smaller than that. We mainly see formal or contracts in a particular form in the areas of real estate. So what is a seal? Well, here are some examples of these. This is an imprint made by an instrument or by a device upon the instrument. When we say instrument here, we mean the contract. Such as an engraved metallic plate or with wax. And the seal symbolizes authority or authenticity. It's an extra way of kind of proving it up, even more proof, say, than a signature. Signatures can be forged. This is a little bit more of a formal proof of it. So when you require a seal, you're requiring a particular format. So when we use the term seal, we're not talking about this guy, this gray seal, and we're not talking about this guy, the performer. We're talking about these seals. You may have seen movies, in the old-timey movies, where the king has a signet ring and there's wax dripped on a document and he presses a signet ring in it. That's a seal. And those are very rarely used. Again, unless you have a real estate practice, you're probably never going to have any involvement with that. So if we don't have a formal document, then we must have an informal document. So it's a document that's not in a particular format, meaning that there's no seal involved. It may again be that 100-page long document that, $100,000 worth of legal bills were expended to get this document. Maybe very, very formal. It can be an oral contract. It can be a written contract. Now you can see that this is the definition from the textbook. A contract not in customary form, often oral contract. But this is the definition that we're going to use. So when you see this in the textbook, ignore it. We're going to go with this definition. A contract other than one under seal, a recognizance, or a negotiable instrument, a contract that is not a formal contract. This is the definition that we're using. We talked about seal on the previous page. There's a couple of other forms of formal contracts beyond the scope of this class. Again, informal contracts can be written or oral. They can be express or implied. Again, the vast majority of contracts are informal. I wanted to close again with our elements of contracts. We have our agreement, which includes offer, acceptance, and mutual assent. We need all three of these to have our agreement, and we need to have an agreement in order to have a contract. We also need to have consideration from both parties. We need legal capacity from both parties, and we need a legal object for our contract. If we're missing any of these four elements, we don't have a contract. We might have an implied in law contract if we're missing one of them. If we have a situation of unjust enrichment, the doctrine of quantum meruit could play a role. And then sometimes, not often, but sometimes a particular contract might be required to have a writing. And that would be a fifth requirement under those circumstances. This is a really important slide. I've shown this several times over this lecture. Be able to understand the parts of this and to be able to talk intelligently about what these particular requirements are as you prepare for tests. I hope that this has been a helpful lecture for you and that you've gotten an overview about how contract law works. Virtually all of the slides that we've covered, there's going to be a chapter, or at least a significant portion of a chapter, that we will do a deeper dive into these concepts. So if you're thinking, gosh, that was so much stuff, you're right, it was a lot of stuff. And don't worry, we're going to fill in the details. We're going to put the flesh on the bones. I think we began this here. We started being really, really far above the world, the 50,000 feet view, and by the end of the course, we will be down in the weeds, looking at the very small details. Again, thank you for your attention. If you have questions, don't hesitate to email me or call me. Stop by my office hours. I'll be glad to provide more examples. We can talk about things in more detail. I thank you for your attention. I hope that you have a great day.